But the Brook Jackson key tam whistleblower lawsuit was before the Fifth Circuit Court of Appeal. I listened to it live. I did my best not to interrupt, but we watched it live or listened to it live on Thursday. This is the key tam fraud lawsuit case against Pfizer that Brook Jackson, a citizen, took for and on behalf of the government that was not taking this fraud lawsuit itself, defrauding the government because Pfizer was supposed to prepare a safe and effective vaccine that prevented the transmission of COVID-19. They did none of the three. The Biden administration, after 2.5 years, comes in, takes control of the case, and then dismisses it. You're appealing to the Fifth Circuit Court of Appeal. They had arguments. I thought the attorney for the government sounded like an arrogant, pompous jackass. I'd like to know who she is and how she got that case and whether or not she's a Biden holdover, why the hell DOJ is still pursuing this. The attorneys for the company doing the trials also sounded sketchy as hell. And Mendenhall sounded great. What was your take of it based on the questions that were being asked by the judges?
Yeah. So those that don't know the background of the case, Brook Jackson is a lifelong worker in the clinical testing of drugs and pharmaceutical space. She came on board she was very excited and very hopeful and very optimistic about a COVID vaccine. She came on board to make sure they complied with all of the various rules, regulations, and restrictions that govern clinical testing. That's not just there for no reason, as was tried to suggest by the government in the case. The reason for all of these rules is that they are necessary in order to make the judgment about whether or not a particular pharmaceutical product is safe, whether or not it is effective, and whether or not it is what it purports to be. In other words, you have therapeutics, for example, you have diagnostics, and you have vaccines. Diagnostics is a medication that's used to literally diagnose what the problem is. Another form of another form of pharmaceuticals, a therapeutic, that's meant to ameliorate the symptoms. An inoculant, a vaccine, is meant to prevent infection and transmission. So Trump in about midway through in 2020, started Operation Warp Speed, which authorized the Defense Department to go and procure a COVID vaccine that could be produced at speed and scale. And who stepped into this was Pfizer and Moderna, along with Johnson & Johnson, whose product ultimately got pulled. But the two big ones, Pfizer and Moderna, promoted a new method of getting there, which was an mRNA platform for the delivery of a vaccine. This is unlike any vaccine in history. There had never been a successful mRNA product in history. Indeed, the problem was mRNA products, if you gave too much of it, tended to cause problems and have all these side effects. So they originally went into vaccines because they thought it would be a one-off. Except the nature of a coronavirus requires you to get constant new vaccines because the virus mutates over and over again. So there are all kinds of critics, Dr. McCullough, others, pointed out, there's Dr. Weinstein, others, that said, look, there's risks of what's called a leaky vaccine. And what happens is you put out a vaccine in the middle of a pandemic, the virus adjusts in such a way that it becomes more dangerous rather than less, and less responsive to a vaccine rather than more. And so all of these concerns are out there. Brook Jackson steps in. She sees what's happening at the Ventavia, which was hired to do the clinical test by Pfizer. And this is all over different locations in Texas. She's there, and they're not following any of the governing rules that are necessary to determine whether something is safe, to determine whether something is effective, to determine whether something can prevent COVID-19. And what the contract they had signed with the Federal Defense Department, both Pfizer and Moderna, was that they would deliver at speed and scale in exchange for billions and billions of dollars and a guarantee of legal immunity for any injuries their products cause. So this was one of the sweetest deals in the history of Big Pharma. You get a product that has a guaranteed built-in budget because it's being mandated on people, and it's from this federal government that can just keep writing checks for forever, it seems these days. And then second, you get complete immunity so that no one can sue you if it turns out your product is crap. This created all kinds of dangerous, distorted disincentives for an actual safe, effective drug. But what they contractually agreed to was to, at speed, at scale, deliver a drug that is safe, effective, and prevented COVID-19 as a vaccine. Instead, what they delivered turned out not to be safe at all. The risk rate, they even falsified the risk ratio data. Wasn't effective at all. It never prevented COVID-19 infection or transmission, and it wasn't even a vaccine. What it was a weak therapeutic that appears to make you more susceptible to COVID over time. The more COVID shots you get, the more likely you will get COVID. Just the opposite of what they guaranteed to the American people in the big billion-dollar contract. She sees that all the testing mechanisms in place are not being used. They're not blinding people like they need to. And what blinding, not like blinding this way, but blinding so that nobody knows who's got the real thing and who's got something that's the prophylactic in order to assess accuracy and not have that bias the processes. They had people's medical records plastered on the wall so that a janitor could see it. They had people literally rolling in the alley, rolling in the hallways because that were suffering adverse events that they were not paying attention to or monitoring. They were doctoring all of the data. So she realized this is a disaster. Goes to her bosses. They say, "Oh, you got to talk to the higher ups." The higher ups, she goes to them, and they say, "This is systematic. This is everywhere. This is where all the labs are going. We have no choice. We're in a rush. This is the golden opportunity. This is what we got to do." And she's like, "This is wrong." So she goes up to Pfizer. And then Pfizer's not doing anything. So she takes photos, takes evidence, shows them she has the evidence. They panic momentarily, and they say, well, they're going to do something about it. They'll shut down the testing. They'll get everything fixed. And then she figures out they're not going to slow down the testing. So doing her legal duty, contacts the FDA. And the FDA, somebody in the FDA leaked to Pfizer that she contacted him because later that same day, she's summarily fired.
So no, that was one of the things that they mentioned during oral arguments, that she was fired 6 hours later, and they said it was for other reasons. She was violating privacy and a number of things which really sounded like documenting the terrible procedure of Ventavia, which is the company doing the trials. Is there any hard evidence that FDA leaked this to Ventavia, or is it just the temporal proximity?
It's just the temporal proximity, and no other explanation has yet been proffered. At that point, British Medical Journal gets involved. First, when she realizes that, she goes to the government, tells them, Bill Barr's Justice Department hides this from everybody. Because she goes to them in the fall of 2020, before there's any drug at all, before any money is ever paid. And the Bill Barr goes to great lengths to make sure President Trump never hears about this. Doesn't even know this is happening. Doesn't know this disaster is waiting for him. They deliberately, Pfizer and Moderna, hold back the vaccine announcement of the vaccine until after Election Day, even though contractually they were supposed to deliver it before Election Day. They had it ready. Well, what they had ready was not a real vaccine, but what they were going to send out, they already had ready before Election Day. They didn't want Trump to win because they knew they needed the product to be mandated, and they knew they needed the product to not have somebody who might second guess them, who might hold them to their contractual word. That's why they sabotaged Trump, even though he'd been a huge champion of this drug, this vaccine, because he thought it would be a magical solution for the COVID problem. Joe Biden gets in. They continue to slow player. The U.S. Attorney, the FBI, other agents involved in this whole process. Oh, don't worry. They're on it. We're on it. We're going to break it, da-da-da. And all they're doing is slow playing her. She gets a little nervous, talks to Robert Kennedy and some other people, and they have her contact me. And I lay out what I think is happening, that they are deliberately hiding this information because they want to rush it onto the world before the world knows what's happened. And I said, because of it, they're going to keep this hidden for another year. And she wasn't interested in that at all. The British Medical Journal, she had a legal right to disclose the underlying facts, not the existence of the suit itself. And so, she complied with all the rules and the laws in that process. British Medical Journal independently vets her story. The British Medical Journal, one of the most well-respected medical journals in the country. They come back and they say her story is absolutely the case, absolutely true. They're shocked. And remember, this was at a time when everybody was saying the COVID vaccine was wonderful. If you took it, you couldn't ever get infected. You could never transmit it to anybody. It had no real side effects. It had a 98% success rate, on and on and on and on. All these were lies. They knew they were lies. The government knew they were lies. Brook Jackson was trying to get those lies out, but the government was in cahoots, covering and hiding that information from the world. So we get British Medical Journal to print it out. That leads ultimately to the court unsealing the case. as the court was supposed to have done before anyway. And then the world starts to find out that this is a very dangerous, ineffective drug that does not even operate as an inoculant. The net effect is that this was right when they were about to force it on young children. So the net effect of what Brook Jackson did by getting this out there publicly is that you can test it in the data. Over 80% of parents planned on having their kids as young as 6 months take the COVID vaccine. After her story goes viral, that gets, along with the work Children's Health Defense is doing and other litigation that we were part of, all of a sudden that number gets down to the low single digits. That almost overnight, parents realize, hold on, something's AWOL here. Something's up here. Thanks to Brook Jackson not listening to the government, trying to hide it for forever. At which point, we go to court. It gets unsealed. First, the judge dismisses, then realizes he made a mistake, reopens, allows us to refile. We refile. The claim is brought on behalf of the American people. Billions of dollars have been paid out to Pfizer. It has similar issues with Moderna and others, but this particular one is Pfizer. Billions of dollars already paid out of taxpayer dollars, and they didn't deliver what they promised to deliver. They promised to deliver something that was safe. This wasn't. They promised to deliver something that was effective. This wasn't. They promised to deliver something that would prevent COVID-19. It didn't. They promised to do a vaccine because it was defense. It says, this is not a therapeutic we want. We want a vaccine. Not only that, they went to great lengths to cover up the utility of ivermectin or other drugs because if ivermectin or other drugs worked, then there would be no excuse for them to have immunity under the PrEP Act. So they go to great lengths to get these billions of dollars by lying to the government about what it is, by firing and trying to blacklist Brook Jackson and smear her in the court of public opinion. They started libeling her and other things like that. They ultimately had to retract a bunch of those. But that was their campaign. And the judge initially dismisses, then he reinstates. He recognizes he screwed up. We go back in, and on the eve of it, looks like we finally are going to get discovery. Years and years and millions of dollars worth of legal time and factual time spent by people across the country in support of this case. And at 1776 Law Center and others, and my firm, Lexi Anderson, and Warner Mendenhall and Jeremy Friedman as the four horsemen to take down Pfizer on the legal team. All of a sudden, the government appears at the last second. And the government says, Judge, you must dismiss. And the judge says, why? And they say, because we say so. That's the scope. And otherwise, they say it's against our public health policy to second guess anything related to the COVID vaccine. And then they go one step further. Then I'll shift to you, Viva. They say that we don't like what Brook Jackson's been up to online. So we would like this dismissed for that reason. So they have a statutory reason that contradicts the Ketam statute. Ketam statute was designed so an ordinary person sees fraud, they can take it to the courts and get remedy. And the reason why they gave that power to ordinary people and not exclusively to the government was because the government's usually in on the fraud. This goes all the way back to the Civil War, where some government agent was lying in his pocket. That's why the blankets had holes in them. That's why the boots had holes in them. That's why the food had rats in it. All the rest. This is where the Ketam laws come from. And all of a sudden, so they come in and say, we don't like anybody that second guesses vaccine. We don't like people who second guess us publicly. And we're not saying there's anything wrong legally with the case. We're not saying there's anything wrong factually with the case. We're saying we're the government and we demand you dismiss. That's the grounds upon which the judge dismissed. No judge had dismissed on those grounds any time before in American legal history. So we take it up to the Fifth Circuit Court of Appeals, where we had the oral argument this past week.
So that was one of the questions that I had is there's timeframes within which the government can take over the case to dismiss it. They waited 2.5 years, and by the time they did it, the principle of good cause needed to be shown. From what I understood, I wasn't sure if that was a statutory requirement, a jurisprudential one, and what you thought of the answer of the government's lawyer to the judge when she asked that question, what's the good cause? And she said, well, because we've decided it. And she said, well, if good cause is whatever you decide, then we didn't need that criteria in the law in the first place. Where is that criteria in the law? Is it jurisprudential or is it statutory? And what do you think of the question and the answer?
So the Ketam laws are designed so you as an individual get to file it, bring it to the government. And the government initially keeps it under seal just in case they want to go to a criminal case or something else to not tip off the defendant. It's not about hiding criminality from the world, which is how the government has now chosen to often use the seal provision. So everything gets filed, it gets sealed with the court so nobody knows it even exists. And they increasingly, while that's supposed to be used to not tip off a defendant so they don't hide and destroy evidence, in fact, it's used to cover up for the defendant so that nobody in the world knows that the scan even exists. It's a complete misuse and abuse of how that part's supposed to work. The second part is they then have a period of time, about 90 days typically, to choose whether to file the case on their own behalf or whether to let the individual, what's called the relator, the whistleblower, bring the case on their own behalf. And in this case, they kept extending that. If for good cause, you can extend that. So that's the first time the good cause is relevant. Is why do you need more time, government, to decide whether or not you're going to intervene? And here's the thing. They lied all the way through because they kept saying they were doing detailed investigation. I've seen no evidence they ever did any. So they kept just going back to the judge and lying and saying, we're so deep in this investigation, judge, we need another 90 days when they weren't doing any investigation. They were lying all the way from the get-go. Bill Barr's Justice Department, then Joe Biden's Justice Department. So at some point, all the way through, they have to have good cause to keep continuing. Finally, they backed off when the British Medical Journal blew up the whole story. They all of a sudden wanted no longer to be trying to hide it. It didn't serve no purpose to keep hiding it because now it was going. The British Medical Journal story about Brook Jackson's whistleblowing went worldwide. Now, the U.S. media tried to suppress it. That doesn't matter in the modern world. It still got out there. That's when all of a sudden the government's like, oh, okay, never mind. We don't want to be involved in this. They couldn't factually shoot down the case. They couldn't legally shoot down the case. So they just withdrew and figured if us against Pfizer and Ventavia, I think they had like a dozen lawyers there at one point, that was going to be a resource mismatch and that we wouldn't be able to withstand it. But myself, Jeremy Friedman, Lexi Anderson, Warner Mendenhall, been in these fights for a good period of time, and that we weren't going to go anywhere. So that was a little bit naive on their part. So we keep battling. And at that point, for the government to come back in, it's under both the federal Ketam statute and under the federal rules of civil procedure, Rule 41 and others, that it requires them to show good cause to intervene in the first place because they're not a party to the case. We are representing the U.S. government, but through Brook Jackson, but they are not a legal party to the case, the U.S. government. So under the federal rules, anytime you're not part of a case, to be able to be allowed to become part of that case, you have to have good cause. In the Ketam instance, they were part of the case from the get-go until they withdrew. But once they withdrew, then they needed good cause to reappear. And the other reason why they're used to lawyers giving up once they don't take up the cause is 95% of Ketam lawyers only want the government to take the case because they know when the government doesn't take the case, it's very hard, it's very costly, it's very expensive. And a lot of your Ketam lawyers are bums, they're big talkers, but they don't do much. They're terrified of having to go to a trial like this. We were not, but they just misread that. But so the government at the last minute realizes that we are likely going to survive all these motions to dismiss by Pfizer and Ventavia. And literally, it was like a week or two before the hearing is when the government shows up. But they had to first file a motion to intervene before they could file a motion to dismiss. They had to file a motion to intervene and say, here's our good cause. And instead, what they said is their good cause. So that's under federal law, under the statute, the Ketam statute, and under the federal rules of civil procedure. They came in and tried to reinterpret everything so they can do whatever they want whenever they want.
Okay. So when the judge asks the question and the answer is, well, good cause is whatever we say it is when we decide to, it gives you optimism that the Court of Appeal is going to come down on the right side?
So now so that's the legal backdrop of how we got to the Fifth Circuit Court of Appeals last week. Then they have the political issues and then the issues that happened that week of. Political issues are that Robert Kennedy's position is exactly the opposite of Biden's administration's issues on the COVID vaccines and vaccines in general. That means the only factual basis they ever cited, which was that it is against the public health policy of the U.S. government to second-guess COVID vaccines, is no longer the official public health policy of the United States government. And so, in addition, there was every reason to believe that President Trump, given the coalition, Maha coalition he was elected with, Tulsi Gabbard, Robert Kennedy, J.D. Vance, others, was going to end all of these vaccine mandates, reverse the impact of all these vaccine mandates, and allow this case to actually be pursued. And then instead, if Matt Gaetz had been made Attorney General, I've no doubt that would have happened. Instead, Pam Bondi is made Attorney General. The people of the Civil Appellate Division, including Yakov Roth, they all have big pharma ties. And particularly disturbingly, Pam Bondi was paid hundreds of thousands of dollars for Pfizer during the COVID time period. So you're like, well, hold on a second. What's going on here? And add to your earlier question, yes, the attorney working the case is the same attorney that's been working the case. So the Biden era attorneys are still working the Brook Jackson case and still pursuing it as if no change in administration had ever happened. And in fact, that was one of the questions that was asked by the judges. It was like, why can't they change their mind? Why couldn't the government at some future point? Because one of the issues is, should the government have been allowed to intervene in the first place? If not, then the motion to dismiss never should have been heard. The second is, even if they should have been allowed to intervene, should the dismissal have been allowed? And third, even if dismissal should have been allowed, should it have been with prejudice, meaning we can't refile? We can't sue on these facts ever again. And for those people out there that don't recognize it, this is the only case that has any realistic chance of COVID accountability. The only case that has any realistic chance of getting real funds into the vaccine injured. Because Brook Jackson's already agreed to assign all of it to, outside of what she would get for her being fired, but basically all the COVID qui tam funds to be assigned to help people recover from injury. So that would be a huge amount of money to the vaccine injury court to be able to help, at least at some level, all the people that have been maimed and murdered by this drug. So this case is huge. If we're going to have any COVID accountability, we're going to have any remedy for the vaccine injured, any aspect, and if qui tam law is going to be meaningfully enforceable so we can do something about fraud. If the government's in on the fraud and can shut it down because of that reason, then qui tam law is a dead law. And we're like Zelensky's government in Ukraine. Everywhere you turn, there's another corrupt corner. And so that's why the case is so consequential. The day of the oral argument, they have on their side the government and Ventavia, the company that directly hired her, that was working for Pfizer, that we have a retaliation claim for. Once we knew the panel, one advantage and one thing I recommend for young lawyers out there is some courts you'll find out the panel way in advance. Sometimes you won't find out till the morning of. But sometimes you'll find the day before, week before, sometimes 2 weeks before. And then you can research the whole panel. And you can, in this case, like the Fifth Circuit has YouTube videos they put up of oral arguments later. You can watch their tone and tenor in oral argument. You can look at their legal history. You can look at their career history. You can look at their philosophical orientation. You can find quotes that are applicable or useful. But you also knew who would be best suited for that particular panel. And so Warner Mendenhall has been doing this work for a very, very long time, very skilled, but comes from a Democratic labor or roots. So if we got a panel that was more of a certain kind of panel, then he would be a better suited person. My inclination would be a bit more flame-throwing, I suppose. And so that would be a different panel. We got a panel of a bunch of judges who had blue-collar backgrounds in their families, had conservative philosophical orientations. These two of these three judges were the ones that told the FDA they had no business telling people about not using ivermectin. Two of them have been very good on issues related to qui tam cases. They've also been good at second guessing the public health authority. They were part of overturning the first Biden era vaccine mandate. So once we knew we had that kind of crowd, knew that somebody that was sort of more delicate, diplomatic, if you will, like Warner would take lead. Warner would do the first 15 minutes. I would do the last 5 minutes. And the government would do their 15 minutes and then Ventavia his 5 minutes. On the way there, God didn't want me to get there, I don't think, because I got to the airport at 8 a.m. Supposed to get to New Orleans at noon. I got to New Orleans at midnight. And then I wake up dead sick. Warner was also already sick. So the question was, which one of us sick people try to get up there and go through it? And because Warner is much more diplomatic than me, I figured it'd be better for Warner, given that I thought we had a fighting shot with this panel. And in front of recent courts, my patience has been diminishing of late. So I gotta. It's not always easy to sit there and keep your mouth shut when you hear stupid crap from the bench. So I didn't think we would hear that from this particular panel, but I knew that if I did, how exactly I would respond it'd be better if Warner was there, especially if I was in bad health already, which I was that morning. So Warner gets up there, And one other cue for people out there, if you're trying to read the tea leaves of oral argument, this isn't always true at the Supreme Court level, but it is true at every other court level. When they've done testing, 85% of the time, and whichever lawyer gets more questions loses. So I've found this fascinating. So I even started listening to old oral arguments in order. Like people ask me, how do you prepare to be an appellate advocate? I recommend just go and find really good oral arguments, really good. See put yourself in their position and say, okay, if I got that question, how would I have responded? You always respond in your head much better than you do in the moment. That's just the nature of life. But it's a good way to learn. And this hearing was good. Well, they got a lot more questions than we did, and they clearly got the issues. That, if the government can shut down this case, of all cases, for these reasons, of all reasons, then we have qui tam law is dead in America, fraud law is dead in America, and there'll never be accountability for COVID. And so these judges know that. Now, what they're up against is the powerful governmental establishment that says if we tell you to do something, you do it. And the courts, unfortunately, are not used to standing up to federal prosecutors and federal lawyers in these cases. So that's the hurdle we're running up, is the institutional establishment barrier that tends to be reflexively in their favor. But I feel good. I mean, my favorite one, you even had a good response. Your response was pretty universal. When they asked the Ventavia lawyer, do you think we're supposed to think it's just a coincidence that on the same day she goes to the FDA to explain all the fraud, that it's just a coincidence you fired her a few hours later? And the Ventavia lawyer's like, yes. Can you imagine having to say that?
It was so stupid because it's exactly the type of panicked response you'd expect from bumbling idiots, where they say, "Oh my, she went to FDA, fire her!" Like, don't set up her firing with anything. Fire her within 6 hours, and then say it was a coincidence because she hadn't applied for whistleblower protection, and so technically she wasn't a whistleblower when they fired her. That answer was laughably stupid, and even the reasons they gave for her being fired, they said it was for cause because she was sharing confidential information or accessing it. I'm like, that's exactly what she was alleging was going wrong in the trials.
Yeah, exactly. So if these judges are as conscientious as we could hope for out of the Fifth Circuit, they're law review judges, are very, very erudite, very intelligent. They ask questions that would point to our direction. So as long as they have the courage of their convictions, then I think the case is going to get reinstated. At a minimum, the Pam Bondi, if she does not herself get proactive in reinstating this case, she should be fired. Now, there's 100 other reasons why she should be fired. But this case is one of the most egregious mishandling by the Justice Department of any case during the Trump administration. And unfortunately, that's saying something, because Bondi has made mistake after mistake after mistake in light of the Epstein and other kind of cases.
Well, and this is the one that I was recently discovered, which was really blackpilling, is her relationship with Pfizer is one that explains the corruption. It explains the bias, and bias at this level is corruption. She was employed by them at the relevant period. She knows the skeletons in the closet. Ventavia running a shit show of trials, and the government coming in and saying 2.5 years later, on the eve of discovery, we're killing this lawsuit because we've said that we said so. And that's the good cause to do it. When do you expect a decision in this?
Within the next 4 to 5 months.
Yeah, that's too long.
That's quick these days. Sometimes you doesn't have it for a year.